Good afternoon, everyone, and welcome to today's webinar, the third in our four-part series for April is Fair Housing Month. This week's webinar is entitled Fair Housing Nuances, a Watercooler Chat. My name is James Campbell, and I'm the Senior Manager of Industry Relations with NAA. I want to welcome all of our members in attending. Thank you for joining us. For this presentation, we wish to alert you to VSTO's Professional Fair Housing Program of courses. The URL is featured below. We also wish to alert you to NAA's Click and Lease and Click and Comply programs for all your leasing and building maintenance compliance needs. Before we get started, I want to go over a few housekeeping points. First, this presentation is being recorded and will be posted to our website and YouTube channel next week. You may then share this presentation with those colleagues and friends who are unable to attend at present. Second, we have a lot of time at the end of today's presentation for live questions and answers, but you may also type your questions into the Q&A or chat boxes on your screen at any time during your presentation. Next, a brief disclaimer that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all content provided is for general informational purposes only. With that, let me turn things over to Aisha Beverly, NAA's General Counsel. Aisha?
Thank you, James, and welcome to our audience. My name is Aisha Beverly. As James mentioned, I'm NAA's General Counsel. I'm extremely pleased to introduce our presenters today. We have Todd Whitlow, a partner and principal with Brownlee, Whitlow, and Praet, PLLC. Todd has represented rental housing industry clients for over 10 years and heads the firm's property and community management divisions in the Carolinas and in Georgia. This includes risk management and litigation services for housing providers, fair housing investigations and complaints, and contract negotiations and drafting. Todd is involved in legislative and government affairs at the national, state, and local levels, and is a faculty member of NAAEI. Norman Praet is a managing partner of Brownlee, Whitlow, and Praet, PLLC. Norm has spent his career representing real estate investors, property owners, property managers, and the owners of small to mid-sized businesses. He also serves as general counsel to the board of directors of the Apartment Association of North Carolina, the Triangle Apartment Association, and the Greater Charlotte Apartment Association Education Foundation, while serving as an NAA PAC trustee. I also note that Todd and Norm are our NAA Click and Lease reviewing attorneys, so I have had the pleasure of working with Todd and Norm on a very regular basis. And with that said, Todd and Norm, the floor is yours.
Thank you, Aisha. We're going to start out with our water cooler chat here, talking about source of income as a protected category under the Fair Housing Act. Can you advance slide, please? The text on the screen now is that shared by NAA and NMHC about source of income. For anybody who's unfamiliar with it, essentially it's a effort by the states, cities, and now the federal government as well to have Section 8 vouchers a protected category. Often it'll be put together in a bill, and the arguments will be that it's based on people not accepting alimony payments or child support or anything, or being able to show those as income. But usually, really, when you read down, the brunt of it is the Section 8 housing. And the apartment industry as a whole is certainly not against Section 8 housing, just that it should be an optional program rather than a mandated program as it was intended originally. This is largely because the regulatory burden that it places on the communities, the additional training and complexity required, delay in inspections that results in delayed occupancy and lost rent. Please advance the slide. We have a graphic up there provided by NAA and NMHC showing how throughout the country, source of income is a very important topic and a very discussed topic. You'll see some states on there, including Texas, that have preemption against source of income protections at this point. There are a number of states that have it already as part of their law. Virginia was another one who just fell under source of income protections, but the apartment association there was able to tweak and change somewhat the original proposed language for the source of income protection to make it a bit more friendly to landlords. And there are other states on there now that don't have it, and states such as North Carolina, where we're seeking to exempt and have legislation currently pending to exempt North Carolina from source of income protections. As I mentioned, the federal government's looking into this now, and it was one of the third points under the Tenants Blueprint for Bill of Rights published by the White House recently. HUD is looking to put out a guidance on, or looking at putting out a guidance on source of income protection as well. So we will certainly continue to hear more about this. Next slide, please.
All right, with that, I'm going to pick up where Norm left off and discuss the new old disparate impact test. This is not like new Coke. This is much worse than that. This is basically the Biden administration recognizing that the 2020 or 2019 rule that was imposed during I believe it was the Trump administration, that they are going back to the three-part test, which this is a good transition from source of income to disparate impact, because some would argue that disparate impact already applies to source of income related arguments. And as you'll see when we get to the kind of ping pong test that is now in play on this three-part burden shifting obligation that the court has to go through to establish whether or not there is a disparate impact in place, we'll kind of discuss those particular issues. Can you advance to the next slide? So it's important to kind of understand, by this point, I'm hoping that everybody who's on this webinar understands the difference between disparate treatment and disparate impact, but I do think it warrants a little bit of time to go over it and kind of acknowledge the differences. I would say very few people within our industry intentionally commit to disparate treatment. That would be direct discrimination with an intent to discriminate. Those do not, in my experience, I have rarely seen a client that establishes a policy that is intended to discriminate against anyone within a protected class. When you then transition to disparate impact, what we like to define it as is a facially neutral policy that, when applied to everyone, impacts a particular set or subset of people in a particularly negative way. And usually those people must be in a protected class. That would be your race, color, sex, religion, origin, national origin, familial status, or disability. You can advance to the next slide. So then we get to the three-part disparate impact analysis, and this is the new old rule. So this was the rule that originated out of the Inclusive Communities case that was from June of 2015, where the Supreme Court recognized for the first time the theory of disparate impact as it applied to the Fair Housing Act. So the first obligation, as you see here, is for the plaintiff or the resident or whoever the wrong party is. They need to show that a practice results in or would predictably result in a discriminatory effect on the basis of a protected class. This is really a math equation. They've got to show what the policy is and how, when it is applied, it negatively impacts their particular category of protected class. Then the burden shifts over to what we would say the landlord or the respondent. And in that instance, the burden of proof would shift to our corner to show that the challenge practice is necessary to achieve one or more of its substantial, legitimate, non-discriminatory interests. If we can establish that, then again, the ping pong goes back to the other side of the net, and the tenant or the plaintiff is then required to show that there is a less restrictive way to achieve that same substantial, legitimate, non-discriminatory interest. The Biden administration went back to this three-part rule primarily because they felt that the five-part test that was in place, or that was attempted to be put in place, was too onerous for plaintiffs and for residents or any wrong party who had been discriminated against to establish, because there were some protections in place for the respondent where they would have to show necessarily that the less restrictive means to achieve the substantial, legitimate, non-discriminatory interest did not create an exorbitant cost for the respondent. And so now all of those requirements are gone, And then I want to circle this all back around to source of income, because if you participated in these webinars all month for Fair Housing Month, then you probably sat in on the first session with Doug Chasik, where he mentioned source of income, and he said that, you know, two words come into play, and those two words were disparate impact. And one could argue that source of income could be considered a protected class already, predominantly because of disparate impact and because of the socioeconomic injustices that exist within the United States of America. There's a high incidence of minority individuals receiving Section 8 housing choice voucher recipients. And as a result of that, where you have a policy in place that says you don't participate in this program or we don't accept housing choice vouchers, it can create this argument. It's something to be aware of. That's kind of how we came up with the idea for this webinar. Was these are the things that kind of we talk about around the water cooler as theoretical defenses. You can advance to the next slide, and I'm going to pass it back to Norm. Actually, I'm not. Sorry, I was one slide early. And disparate impact has been applied in a number of cases recently. One of them in January of this calendar year, the United States government filed a statement of interest in a fair housing lawsuit involving two African-American rental applicants who were housing choice voucher recipients. And it alleged that the credit screening process caused unlawful disparate impact amongst African-American and Hispanic rental applicants, because the underlying algorithm relies on certain factors such as payment history on non-tenancy related debts, your tenant history, and it failed to consider that the use of the housing choice voucher, that basically they have this pool of money there to pay the rent, but you're using factors that are really based on considerations of the person's ability to pay the rent, and they weren't kind of meshing the two. That case is still pending, and we'll see how that turns out. You can advance to the next slide. And then this one is in December of 2022. This one is interesting for any rental registration communities that may exist out there, whether it's at a state level or a local level. There's a consent order was entered in federal court in California related to a policy established by the City Council of Hesperia in San Bernardino County. It established a crime-free rental housing program that required all rental housing providers to, number one, obtain a business license. And the only way they could get a business license is if they participated in this crime-free rental housing program, which required criminal screening of any residents that were going to be living within their home or their rental property. And then it required them to sign a crime-free addendum. This case is, it ended up in this consent order, which ultimately required some remedial action in the doing away of this particular program. So again, it's something to be aware of, and disparate impact has been applied in a number of other cases since it was recognized in 2015, most notably criminal screening, but it's also been argued to be applied towards eviction records, reviewing the eviction record history before evaluating whether to rent to someone. It's been applied towards actually national origin in a case, I believe, in Northern Virginia. And so again, it's something that the use of it is going to continue to be expanded. You can advance to the next slide. Now I'm going to pass it to Norm.
And another topic we find under fair housing that we see many complaints under: family status under the Fair Housing Act. Please advance to the next slide. Family status includes the presence or the expected presence of children under 18 years of age, pregnant women, individuals securing the custody of children under 18 years of age, and then maximum occupancy criteria. The prohibited acts really are refusing to rent to families with children, evicting due to children coming to the property after there's been a rental, requiring families to live in certain units on the property because they have children, and advertising indicating children are not welcome. And the two issues that we see the most are rules that quote unquote unreasonably limit children's presence or activities, and occupancy standards that are more restrictive than reasonable local ordinances. Occupancy standards Those are continuing to be addressed through the country and from HUD. Often 2+1 for a family of 2 plus a minor child, and a 1-bedroom is seen as okay, but you really need to look at your local ordinances, and also limiting children's presence and activities. Those come up often in children under the age of X can't go to the pool without an adult with them, or they can't use the exercise equipment, or various other, or they can't be in the common areas, they can't be playing outside. What that number X is makes a big difference in the category. And though many of these regulations are well intended to protect the children, to protect the other residents in the community, and some may seem more common sense than not, people are getting in trouble under the Fair Housing Act, as we'll see in just a moment. One exception to the Fair Housing Act with respect to familial status is lawfully operating older persons communities. Under the Housing of Older Persons Act, or HOPA, you can have certain criteria that people need to be 55 and older in a certain percentage within the communities. Next slide, please. $3 million. These are a couple recent cases, where one in which a $3 million settlement was reached under California Fair Housing Act for restrictions on children under the age of 14 being able to play, requiring adult supervision to be able to play outside. And then a consent order was recently entered in a Florida case that allegedly discriminated against families by refusing to give building access devices to minor residents, prohibiting children from common areas without supervision, and misrepresenting the availability of units to families with children at a multifamily community. So the biggest area we probably see here are the children, limitations on children. And unfortunately, there's no necessarily bright line rule as to what age for what activities. So you're safest if you err by making the age as young as possible for restrictions, 14 rather than 18 or 10 rather than 14, but we don't have an exact number that we can speak to. Next slide, please. Just going back to Todd for anything else you wanted to add there, or the accommodations and modifications.
Yeah, I mean, I think, our records, and I think even HUD's records indicate that familial status is now the third highest amount of claims that they receive on an annual basis. And to Norm's point, I think what most of it centers around is the fact that the person, in our respect, the housing provider's heart is in the right place. They're, care about the concern and safety of the minor occupants, and making sure that they maintain some level of supervision for that minor occupant. But what we try and advise our clients on is try and avoid using the word children in any policies to the extent you can. I mean, if your policy is in anyone 18 or older must be a resident, then just call them an occupant. Just change the word child or children to occupant or occupants, and then avoid using terms that only really apply to children, like playing or toys. Don't say no toys stored on the balcony. Just focus on personal property other than appropriate outdoor furniture, and you should be fine. Which now transitions us to the number one thing that we see on a regular basis, and probably the one that we see the most predominant number of fair housing claims that we get called in on, is accommodations and modifications. So let's advance to the next slide. So it's important to understand this is under the category of disability. Obviously, those are the only people that under the Fair Housing Act that warrant an accommodation or a modification. This is the definition under both the ADA and the Fair Housing Act for when an individual is considered disabled. And the key components of this are, it needs to be an impairment that substantially limits one or more major life activities. The list of major life activities has continued to grow over the years. And I mean, this list is not intended to be exhaustive, but some of them are walking, talking, caring for oneself, learning, working. Mobility is obviously one of those key central points. You can advance to the next slide now. So the difference between accommodations and modifications are And hopefully most people know this at this point, but accommodations are really a change in the rules or policies that allow the individual with a disability the equal enjoyment of housing. And then modifications are changes to the physical characteristics of a residence or to the common areas of a building. You can advance to the next slide. Some examples of reasonable accommodations. Some of these are fairly obvious. A couple that are not as obvious that have come up recently, at least one that's been around for probably a good bit of time, but one that's come up recently is if you have an individual whom you know as a result of their application receives disability related income, and they receive the income at a certain time of month, say, you know, the 5th, the 10th, the 15th, whenever that particular payment hits their account, and they make a request upon the landlord to move their due date to coincide with the day on which they receive their disability payment. If you had asked me a decade ago whether that was an appropriate accommodation, I would have told you it was a budgeting issue and not a disability issue. But there are at least some courts in this country that have disagreed with my position and have said that is a reasonable accommodation and that a landlord should consider, you know, once you factor in all the specific facts and circumstances of the request, that it can be deemed to be reasonable. You would then modify whatever your late rent policy is to be, you know, some period of time after that established due date. The other one that is sometimes less than obvious is if you have an individual who signs a lease, but then ultimately during the term of the lease, as a result of either becoming disabled, whether it can be, you know, they establish or they're diagnosed with cancer and it's advanced rapidly to the point that they're at stage 4 cancer, or if it's someone who ultimately is suffering from early onset dementia or Alzheimer's or some other illness that prevents them from being able to live on their own, and they actually request to terminate their lease early with no further liability, there have been some courts that have established that that can be a reasonable accommodation, even though the intent of accommodations is to allow the disabled individual the use and enjoyment of the premises, not to terminate it. You know, HUD has kind of turned it on its head and determined that that can be a reasonable accommodation. You can advance to the next slide. A reasonable modification to a building might include installing ramps, installing grab bars, widening doorways where appropriate, or possibly installing a lift. You can advance to the next slide. The important question when it comes to modifications is who's going to pay for the modification? And the answer is going to vary depending upon the facts and circumstances of your particular property. For example, if it's a 504 property and you receive federal funding for purposes of the development of the property, then you're going to end up paying for it. The federal government has established that if they provided funds for developing the community, then you get the responsibility of paying for these modifications. But otherwise, if you are a market rate property, the majority of the time, it's going to be the resident that's responsible for it. I think you want to be involved in the process because you want to make sure that things are done appropriately and are done to code. You can also require the resident to be responsible for acquiring any proper permits and ensuring the work is done properly. And you can even have them, this is not to be confused with a security deposit, you can have the resident put money into an escrow account that sits there until the end of the lease term for purposes of paying to restore the unit back to the condition it was in before they made the modification. One thing that's worth mentioning with this particular slide is when you get a request for an additional handicap spot or for reserve parking, HUD has a really unique way of dealing with that. I would have said that asking for an additional handicap spot because of the curb cut, all the painting that you need to do would be considered a modification, but HUD considers that a reasonable accommodation. And the reason for that, I believe, is because it shifts the obligation to the housing provider to pay for that particular accommodation. So you can advance to the next slide. So the reason that this is, you know, a high incidence of claims is because of the very nuanced nature with which this stuff comes in. A resident does not have to use any magic words. They don't have to say, I'm asking for a reasonable accommodation or a reasonable modification to be considered to be making a request. Basically, any statement that the resident makes that would be considered to be clear that they are requesting either a change to the usual policy as it applies to them, or for a structural or modification to their premises can be considered an accommodation or a modification request. And then most importantly, I know, we are the click and lease attorneys, and we know that there is a reasonable accommodation form that you can provide to the resident to have them fill it out. Just always be mindful that you can't mandate that they fill it out. You can suggest it. And my usual advice to clients is if the resident is unwilling to fill the form out, that you interview them and then you pair it back exactly what they're asking for when you write it down on the form. And then you try and have them sign it, or at the very least you sign it and then make a note of the date on which it was requested. You should always immediately, your site level teams should be passing up these accommodation and modification requests as soon as possible to whomever. We've got some clients that have like a team or a cadre of regionals that sit on a panel and make this decision. Sometimes there's one individual. You just want to make sure that there's always a backup, because HUD views it as any undue delay in responding to one of these requests equals a denial of the request. And they kind of set that time frame at somewhere around the 10-day threshold. So you need to push it up and get it back down and get a response back to the applicant or to the resident as quickly as possible. And then if you need additional feedback from the resident or some additional documentation that wasn't provided, you want to request that as well. With that, I will wrap up, and if we have any questions, we're happy to answer them.
We do. I know we have 3 minutes left in the presentation, so we have 3 questions. And the first question is, what if minors are disturbing other residents and leaving things in the breezeway that cause a trip hazard? And after speaking with the parents, they refuse to help the situation.
You could probably, depending on your lease, you could probably address that just as any other resident violations, and disturbing the other residents and creating clutter, and send a notice to for them to stop doing that, or their lease will be terminated. It doesn't have to have anything to do with their minors specifically. If any other resident was engaging in those same behaviors, you would likely move against them.
Perfect, thank you. And the next question, a lot has changed with Section 8. We used to say very politely that at this time we do not participate in the program, and refer them to other properties around us that they knew accepted Section 8 vouchers. Now that they cannot say that anymore due to fair housing, they now say that they welcome all applicants and go over the screening criteria. However, it still leads to the caller or the applicant wanting a yes or no answer. What would be the best way to follow up this question without saying no?
Yeah, that one's pretty nuanced. I mean, it's always going to be a delicate issue. I mean, I think, the biggest concern that we always have is when it comes to source of income, a lot of our clients have income criteria. They require 3 times the amount of rent in income per month in order to qualify to live there. And the question always becomes, what happens when an applicant has a housing choice voucher that is exactly equal to the amount of the amount of monthly rent? And in that instance, I think it puts the housing provider in a rock and a hard place, depending upon obviously where your property is and whether source of income is a protected class. Did you want to add anything to that?
Well, just even if, as you indicated earlier, even if it isn't a protected class, they just need to be mindful as to disparate treatment or disparate impact arguments and things like that. So it's a business decision on their end, but there is certainly, it's safest to accept them. But that is, unless there's a law specifically stating that's a business decision, and they just have to weigh the risks.
Right. And at that time, we would always recommend that the individual check with their local council as well to make sure they are in line with state and local laws on the matter. So just throw that in there too.
Absolutely.
Last question, Todd, this goes back to your speaking of the cases on disparate impact. The attendee would like to know the names of the referenced disparate impact cases that you were speaking of.
I'll have to get that. I'll forward that to you separately, and then you can circulate it to the registered attendees. I don't know that I have that information immediately handy.
Perfect.
And did they say which ones in particular, the ones that were referenced in the PowerPoint?
Yeah, you referenced them during your presentation on disparate impact.
Okay, okay,
But those
All
are
right.
published by the Department of Justice also.
Yeah.
Which is where we pulled them from, but we're happy to follow up on that.
Absolutely. Thank you. At this time, we are at 12:30, so are not going to be able to take any more questions. And I yield the floor back to James to close us out.
Well, terrific, Aisha, and thank you again to our two outstanding presenters for this webinar. For additional fair housing resources, NAA maintains an online portal for especially relevant offerings for NAA members. The URL is featured below. These resources include the remaining webinar in our series entitled Accessible Design and Construction Requirements for Apartments. Be sure to register on our website. These resources also include newly updated fair housing toolkits on accessible design and construction, plus emotional support animals. They also include more than 30 fair housing courses hosted on our Visto platform. And there is another portal with additional fair housing resources such as legal explanations plus protections in state and local jurisdictions. The URL is featured below. Finally, if you've enjoyed today's webinar and would like to view more, you can always visit our YouTube channel for those many NAA webinars that are now viewable on demand. The URL is featured below. Again, I wish to thank everyone for participating. Special thanks to our presenters, Todd, Norma, and Aisha. Thank you as well to our audience. We value your membership and appreciate your attendance. Have a great afternoon.